Artificial intelligence is changing the way lawyers work, but it has real-world implications, and one of those is the impact on attorney-client privilege communications. That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney. For over 20 years, I've drafted and negotiated a variety of technology-related contracts and litigated failed ERP implementations in courts across the country. Two decisions recently came down addressing how generative AI interacts with privilege and work product issues, but they came out with two wildly contradictory opinions. The first one is Warner v. Gilbarco in the Eastern District of Michigan, and there the magistrate judge held that a pro se plaintiff that was utilizing ChatGPT prompts to assist it in connection with drafting litigation materials, the judge in that case held that those were protected work product and not discoverable. And the rationale behind that was that generative AI is really like a software product that attorneys use in connection with conducting research, checking their work, or reformatting their material impressions. And he said AI does not waive work product absent disclosure to an adversary. The second case is United States v. Heppner, and this is a different analysis. And here the court ordered production of AI-generated documents that a criminal defendant created with a public AI tool, and in this case it was Claude, after receiving a target letter holding that they were neither attorney-client privileged nor were they work product. The materials were created unilaterally by the client using an artificial intelligence public tool, and in that case, the judge reasoned that use of this public tool had waived the privilege in its entirety. So what are the differences between the two cases, and how did the judges arrive at different results? In Warner, AI was used as a drafting and research aid closely tied to preparing litigation filings and materials were treated as expression of the litigation strategy and mental impressions. And if you look at Heppner, AI exchanges were more like the client talking to an outside non-lawyer about the case, and the court viewed the AI tool as a third party not integrated into counsel's work. The focus was on Rule 26b3, work product protection and proportionality, not attorney-client privilege. And the court emphasized that no case required production of internal mental impressions reformatted through software. And again, you contrast that with the opinion in Heppner, where the court squarely addressed attorney-client privilege and work product and found both inapplicable: no attorney-client communication, no reasonable expectation of confidentiality, and no work prepared at the behest of counsel. And so I think, two wildly different results, and I think there are some key takeaways and certainly some key lessons to be mindful of. So what are the lessons for clients? And I think don't treat public AI as a private confidant. Heppner underscores certainly that putting sensitive legal facts or lawyer advice into consumer AI products that logs or trains on inputs can destroy privilege and work product. You've got to expect discovery into your artificial intelligence use. Courts and opposing counsel are going to increasingly probe how you used AI platforms in civil litigation matters. They're going to want to know how you interacted with it, what documents you might have put into it in connection with that case. And I think you've got to just expect that all that is going to be discoverable. And if you're going to be careful, you're not going to want to be utilizing AI in connection with what your lawyer has told you, the documents or drafts that your lawyer is providing to you. You might be able to find some solace in the fact that you're utilizing maybe a non-public tool, maybe then that the result would have been different. I think anything that is going to be put into anything that is publicly available, so non-confidential AI tools, certainly was a key factor in the Heppner case. Your use of AI needs to be limited in the context of litigation. You need to be advising your attorney, certainly if you are utilizing artificial intelligence. And I think this has become incredibly common. It's very common in my practice for me to send a draft demand letter out, a draft complaint, a draft motion, and for my clients to run that through ChatGPT or whatever AI tool they happen to be using. It's not always easy to tell that they're actually doing that. I mean, you get back very sophisticated questions from a client that may not be particularly sophisticated, or the commentary doesn't really have the context necessary, in light of the work product that you've provided. And what I mean by that is, it's raising points and analysis that, while they may be relevant, they're not particularly important for the issue at hand. And so I think, as we move forward with artificial intelligence, it's certainly a wonderful tool to be utilizing certainly if you're a lawyer. And certainly I think it can empower clients to feel confident in the legal process and what their lawyer is telling them, and for them to, make good decisions about what is happening in their case. But I think it all carries a significant risk, and you've got to be careful. I mean, if you're going to utilize AI, just understand that there is a significant risk that you could destroy privilege and that all of that material could be discoverable. Attorneys are going to be asking for this information, and depending on the jurisdiction that you're in, they may very well be entitled to it. If you have any questions about any of the issues in this video, please feel free to reach out to me. I'd love to talk to you and get you pointed in the right direction.